Good morning. My name is Bridget O'Brien. I'm the Deputy Court Administrator at the 8th District Court of Appeals, and it's my pleasure to introduce this segment's moderator, Erin O'Toole. Erin is the Court Administrator and Magistrate at the 8th District. She is a certified court manager. Prior to rising to the position as court administrator, Erin served as a judicial attorney, a staff attorney, and the deputy court administrator. Erin has over 20 years of experience at the court. You probably could not find a better person to moderate a discussion on practicing in the 8th District Court of Appeals. Erin's detailed legal experience prior to joining the court is detailed in her bio, which you can find on the law school's website, along with all the written materials for this segment and the other segments. Outside of the court, Erin is a passionate advocate for persons with disabilities, and she proudly serves on the Down Syndrome Association for Northeast Ohio. Please welcome Erin O'Toole.
Thank you very much. Can everybody hear me? I just want to take a second here and thank Bridget. Without her, this would not have happened. And of course, all of our judges of the court being so committed to education and interacting with our court users and practitioners. So also thank you all for attending here in person or on Zoom. And thank you to Case for hosting this, and specifically Eric, thank you for all you've done for us. We have a lot of material to cover because as you see here, we have Andy, Jake, and Dave. They're our staff attorneys. They have a ton of duties at the court, but in addition, they serve along with Jim to answer questions. They will call you. You can talk to them directly. You can walk in and talk to them. We are committed to serving the public and you as practitioners. They will answer your questions of appellate procedure, but please reference the materials that we have on our website before you call, because they do have a lot to do. So,
but we won't do your research for you.
Thank you. Here we represent over 80 years of combined experience at the court, and that doesn't include, and if you throw mine on that, let's say 100. So really, if we don't answer what you're looking for here today, give us a call. We're available to you. So let's begin.
My name is David Parcham. I have been a staff attorney with the 8th District Court of Appeals for over 32 years. Among our duties is to jealously guard the jurisdiction of the court. And the primary way we do this is through screening of cases. Screening began even before I came onto the court, when the judges examined the file and questioned whether there was a final appealable order. So they put the file on the podium, and when the appellant's attorney came up, they said, counselor, show us in the file where there is a final appealable order. And that was the start of the screening process. So we get an opportunity to determine whether this court has jurisdiction. We look at a few other things. We look at timeliness. We look at finality. We look at the briefs to make sure they are compliant with the rules. And there are a few other things we'll look at. But the primary purpose is to guard the jurisdiction of the court. Now, in regard to timeliness, you all know you have a 30-day time limit in which to file your notice of appeal. If you miss that 30-day window, you're clipped out. The court doesn't have jurisdiction. We couldn't help you even if we wanted to. A couple of things to remember. Probably the most new important thing to remember is that with the advent of electronic filing, judgment entries get entered on a Saturday and Sunday sometimes. Pursuant to case law, this is when the clock begins to tick for your filing of your notice of appeal. It doesn't kick over to the next Monday. So look and make sure that you are filing within 30 days of the file stamp on the journal entry, even if it's a Saturday or Sunday. Also remember, there is a potential problem for months that have 31 days. If you say, oh, I got 30 days, just go to the next day of the month. Well, if you file, if the judgment comes out on August 15th, and you wait until September 15th, then you've already hit 31 days and you've missed your appeal as of right. We occasionally run into what I call double clutched entries, where the judge will enter the final appealable order, a full judgment on July 1st, and for whatever reason, the judge re-enters it on July 10th. And you file your, somebody files a notice of appeal on August 5th, timely from July 10th, but not July 1st. In those instances, the first one counts, and that's what we look for in regards, one of the things we look for in
And
timeliness.
Jay, just to be clear, it's not the non-compete that you're talking about. These are the exact same entries.
Right,
Entered for whatever reason.
right, that is correct. That is correct. And occasionally, if we look in a day, it looks like the notice of appeal was filed 1 or 2 days later. Well, I'll pull out my calendar and do the computation to make sure that the 30th day wasn't a Saturday, Sunday, or legal holiday. Because if the 30th day does fall on a Saturday, Sunday, or legal holiday, then the due date kicks over to the next day the court is open. But the primary thing we look at is finality. And as Judge Ford said earlier, generally that means all of the counts are resolved and all of the claims against all of the parties are resolved. In the criminal area, the dismissals with prejudice, the dismissals without prejudice, and the nollies of counts all count toward creating a final appealable order. So we will examine and make sure all of those counts are taken into account. Now, pursuant to Baker and Lester, and a sentencing entry, you must have all of the convictions that are specified, the fact of convictions, and a sentence for each count. And it must be all in one document. Now, and occasionally, especially in municipal court cases, we've had problems with this, where the judge on the form checks off guilty on day 1 of a DUI. And then when the sentencing comes around on day 10, this judge just puts in 180-day jail sentence. That's not a final appealable order under Baker and Lester. And, we will have to either send the case back if it looks like it's an authentic clerical error, or dismiss the case if there was an authentic problem. Similarly, blanket sentences can be a problem. This usually comes up in terms of community control, where the judge says there are 3 counts, and the judge says, I sentence the defendant to 3 years community control. That's not good enough, because there isn't a sentence for each count. And this is pursuant to a case called State against Dumas. Instead, the judge has to put in defendant sentenced to 3 years of community control on each count. And under those situations, that will obtain a final appealable order. And as the judge said, occasionally we'll come into all sorts of problems, especially in the multi-count cases, where it's not clear whether or not sentences should have been merged or as allied offenses, or you get some strange journal entry like count 30, a sentence on count 30. That creates a jurisdictional problem, and we will look at the transcript to see what really happened. Such that, there really was an explicit resolution that counts 30 and 31 were to merge. And if that's the case, the court has the right, and has often done, a remand to the trial court to remove the potential jurisdictional impediments. Otherwise, if we look at this and say, no, there really never was a resolution to count 30, the court will dismiss the case for lack of a final appealable order because we don't have jurisdiction.
And if I can just jump in right here, we are trying to prevent that from happening by putting it on the docketing statement. You are supposed to be going through that and certifying to us that you have a sentence on every count. So please do that, because that'll help your case be streamlined.
On the civil case, on the civil side, once again, all claims against all parties must be resolved. And I'll take that, I'll put down all of the parties, I'll put down all of the claims, all the counterclaims, third-party complaints and cross-claims. And as I'm going through the record, I'll check them off to see whether or not everything has been resolved. There are a couple of special rules. You, as Judge Forbes said, you can dismiss an entire party without prejudice, and it will count toward creating a final appealable order. But you can't do that with individual claims, such that if you brought a claim and you got assault and battery, negligence, and breach of contract, and you get your judgment on summary judgment for $25,000 on breach of contract, and you're satisfied, you just can't dismiss the assault and battery and negligence claims without prejudice. Rather, you either have to get 54B language, you may dismiss the claims with prejudice, or you may file an amended complaint eliminating those claims, and then you have a final appealable order. Cases that are referred to magistrates can present special problems. First of all, after the magistrate issues the report, the judge has to approve. If the judge just says, "Oh, I approve the magistrate's report," that's not good enough. Pursuant to a case called State against Zinni, the judge must state the actual judgment. Judgment for the plaintiff in the amount of $25,000. You know, and if you don't have that, there's not a final appealable order. Similarly, after the magistrate issues their report and the judge signs off on it immediately, the party has 14 days in which to file an objection. If objections are timely filed, there must be an explicit resolution of those objections, or there is not a final appealable order, and we don't have jurisdiction. So make sure when you're bringing your case that the magistrate's boxes are checked. And occasionally we'll find some really peculiar procedural problems. Picking up with Judge Forbes's example on a John Doe, we recently had a case where 10 John Does were listed. And there was not service or naming of the John Does, and judgment is rendered for the defendants before a year has elapsed. So the John Does are still outstanding. However, in this particular case, this was a refiled case. And in the first case, the John Does were named too, and more than a year had passed. So this presented the court with a peculiar procedural posture, and the court asked the parties to brief it. And in this case, the party said, "Oh, we have a final appealable order because of these distinguishing characteristics." And the court said, "Okay, we'll go along with that." But the main thing to remember here is when we come across these rather bizarre incidents and we issue an order to the parties to brief this jurisdictional issue, please take this very seriously. Read the cases the court cites, because that will tell you where we're coming from and what our thinking is. And then do your own research, do additional research to help the court resolve these serious jurisdictional problems. We also look at the briefs to make sure they are compliant with the rules, that the briefs are signed, that they have all of the component parts, especially the assignments of error, and that it comes within the page limitation. Remember, for page limitations, the assignment of error and the statement of issues presented count toward the page limitation. And if you start getting over that area, like you get 41.5 pages, well, you're getting into the how lucky do you feel category. You know, will the court strike your brief and say you have to we were requiring a new brief compliant with all the rules? Or we just making sure warning saying the court accepts the brief as filed, but notes that the brief exceeds the page limit by 1.5 pages and appears to have footnotes in less than 12-point type.
We prefer you comply with the rules.
Yes, and in the future, the failure to file a complete brief in compliance with all the rules may result in the court striking the brief, requiring a new one, or imposing other sanctions. And Dandy?
As part of the screening process, we take a look to make sure that there's compliance with local appellate rule 13.2. A little background. In December of 2013, this court adopted local appellate rule 13.1, which deals with electronic filing. Going forward, all attorneys, not necessarily pro se litigants who can take advantage of the electronic filing, are required to file electronically. What does that do? It gets out into the internet. We have the clerk's office has on their website the ability to list everything that's filed in a particular case, and you can go to the clerk's website and look that up. That same applies to the appeals process, where you have everything from the notice of appeal to the final judgment to the motions for reconsideration and the en bancs that are online. They're either TIFF files or they're PDF files. So anybody can go to a particular case and look at that particular case. Now, 13.2 was put into effect to comply, to ensure that certain information was not revealed to the general public. And that included personal, private.
Andy, I'm sorry to interrupt. Can you speak closer to your microphone? That's okay.
13.2 was put into effect to prevent the release of personal, private, and confidential information through the internet, such as social security numbers, financial documents, driver's license numbers, names of juveniles, and victims of sexual offenses. The most important part that we look at when on the briefs is the juvenile names and also the victims of sexual offenses, because, and Dave likes to say, well, this information can get out to the general public, and it can be used, if you're a child, can be used to bully you, or your employer can use this in the future, because everybody has a social record now through the internet, basically, and it can be used to say, oh, well, when you were 15, were you the subject of a sexual attack? Well, that information does not have to be revealed. It does not have to be. So we passed 13.2. And 13.2 is applicable to all documents filed in the court. It includes, but is not limited to, the notice of appeal, prosecuting document statement, the affidavit of innocency, also known as the poverty affidavit, briefs and motions. Local 13.2 B1C specifically provides that a juvenile's name, except for the juvenile's initials or a generic term, such as child, son, daughter, must be used instead of the juvenile's actual name. Now, the majority of the cases that we have deal with this particular issue are juvenile delinquency cases and also adoption cases or parental rights cases. So we screen those very carefully to make sure that no information with regard to the children, or if it goes back to the mother or the father to allow you to identify the children, is in that brief. I just screened a brief the other day where we had to strike the brief because the attorney included parts of the transcript. And the parts of the transcript were with regard to testimony from one of the caseworkers. And the caseworker specifically stated, well, Joan or Sam or Bob or mother or father, the actual names were part of what was repeated in the brief. We have to strike that entire brief. What the party should have done is said mother, father, child 1, child 2, or child 3, or even grandmother or grandfather. So please, in the future, be careful when you're writing your brief to make sure that there's no identification of the juveniles or a victim of a sexual crime. We protect the victims of the sexual crimes to make sure that their name is also not mentioned within the brief. So if you have a victim of a sexual crime or multiple victims, use victim 1, victim 2, or V1 or V2.
For something like high school senior, something like that.
Just so you don't have the actual name of the party, because we looked at these briefs very carefully. You don't want to have to redo your entire brief, because if you're appointed, I don't think we're gonna pay you twice for doing the exact same thing.
No. You gotta move a little quicker.
Yeah, we are really trying to protect the kids and the victims, so they're not bullied. And if you use a parent's name like Fred Fungible, and you use the kid's initial as BF, well, that identifies the kid as B Fungible, and that identifies the kid. And we're really trying to protect the kids. We also check for some other things, like, is this case appropriate for the accelerated calendar? Is there a conflict of interest and hot topic issues? Such that in the constitutionality of Reagan Tokes, we listed and noted all cases raising that issue, so the court could get a good grip on just how extensive and what we need to do to make sure it's all consistent.
I just wanted to add, with regard to 13.2, in the materials that's handed out, we have a copy of the notice of appeal that was properly redacted. We have a copy of the judgment entry from the trial court that was properly redacted, a copy of the Presbyterian docketing statement that was properly redacted, a copy of the affidavit that was properly redacted, and finally, a judgment entry from this court which struck a party's brief because they did not comply with 13.2. So that's all in the materials. You want to take a look at that?
And I am finished, and that's the basic screening process in a nutshell.
Thanks. And Andy, could you go over the amendments?
All right. As everybody knows, there's 2 sets of rules that apply to all of public practice. There's the general rules and the local rules. The local rules modify the general rules in certain fashions or in addition to the general appellate rules. I'm going to go over 3 rules that were changed on July 1st, 2022. Mediation, local appellate rule 20, oral argument, local rule 21, and amendments to local 46, appointed council fees, which I'm sure everybody's interested in because that involves the money. Amendment to local rule 20, mediation. 20 controls the mediation program. Prior to the amendment, all revised code 149.43 original actions that dealt with public records were referred to a panel or to mediation. The mediator would then draw the parties in. They would take a look at see if they can settle the case. It's usually a matter of, well, I want these records. You do not give me these records. Please provide these records. And then there'd be an attempt to settle. David Shively, who's our mediation program authority, he did a very good job in mediating these cases. However, there were certain objections filed by certain panels that did not want to go to mediation. So what we've done is we've changed under C that all cases do not go to mediation under 149 or 149.43 public records cases, but it's up to the panel whether they wanted to go to mediation or not. Under 20D, it was provided for a stay of appeal on mediation, and it was for 60 days. That's been modified. It's not automatic 60 days to go forward for the date of reference. Once the mediation is over with, your case goes back into the hopper, and then it goes forward from there. Mediation 20D added to clarify the council of record for every party, as well as the parties themselves, must attend the mediation. Language also emphasized that if the party to an action does not have full authority to settle the case, then a person with authority to settle the case shall attend the mediation. copy of the local rule is in your handout. Local rule 21.
This is a big one.
Local rule 21 governs oral argument. Prior to the amendment, which was effective on 3/1/22, oral argument was presumed on all cases. You didn't have to do anything. If you wanted to opt out of oral argument, you could file a motion with the court, but that does not apply anymore. What happens now is that if you want oral argument in front of the 8th District Court of Appeals, you must request oral argument. The request is made on the cover of the brief. Don't put it down in a little 10-point type or anything like that, or at the bottom of your signature. Make sure that it's in bold letters, request oral argument. Now, one party is all that is sufficient to request oral argument. Both parties do not have to request oral argument for it to go forward. So for instance, if the appellant requests oral argument, it's set for oral argument. If the appellee requests oral argument, it's set for oral argument. Do not use the reply brief to the answer brief to request oral argument. It's either in the main brief or in your answer brief.
And just as a caveat to that, we do allow you to request Zoom arguments if you prefer that. And we have that laid out on the website, how you go about doing that, or give us a call.
Okay, 21A1 is how parties now will be notified of the hearing, including reference to the court's website, reviewing the oral argument schedule. We have a complete schedule going forward, like 6 weeks now.
It's 5 to 6 weeks.
5 to 6 weeks of cases that are scheduled for oral argument in the future. 21A2 requires that the parties be notified of the date on which the case is submitted to a panel for a decision when no oral hearing is requested. So people look at that schedule and say, well, I didn't request oral argument. And I'm scheduled for a hearing. Well, if there's no oral argument scheduled, that is the date that the panel will consider that particular appeal. And then they will conference the appeal and then come up with an opinion. Make sure that you understand that you're limited to 15 minutes of oral argument and that's it. In certain circumstances, you can request in advance by motion to extend the 15-minute period of time, but that's very, very rare. If you want rebuttal time, make sure before you start your oral argument that you petition the court that you would like to reserve 15 minutes or 5 minutes, 7 minutes, 8 minutes, whatever you want for rebuttal. Amendments to local appellate rule 46, appointed counsel and fees. Local rule 46 expands the appointed counsel list to include attorneys, appointed counsel in juvenile and termination of parental rights cases. It clarifies that appointed counsel seeking reimbursement for fees must attach 2 documents to the application for fees: a completed financial disclosure form and a copy of the judgment entry appointing counsel to the appeal. It clarifies that the applicant for payment of attorney's fees shall be filed with the clerk of the appellate court, not the clerk of the trial court from which the appeal was taken, or the county. It gets filed with our clerk of courts. It clarifies that the timing of when to file an application to be no earlier than the release of the opinion and no later than 30 days after the appeal has been journalized. If you miss that 30th day, you may be penalized by no payment of fees or a reduction in the fees. I want to emphasize 30 days is 30 days, it's 30 days, unless it falls on a weekend. But even then, please file within 30 days. And finally, I have attached in the material, we have an application to serve. Oh, the application is only good for 1 year. You have to renew your request to be appointed counsel on a yearly basis. I've also attached the motion and certification for appointed filing fees, a listing of the itemized fee statement, and also a schedule of the fees that have been adopted by Cuyahoga County. The fees are no longer part of the rule. They are listed as an appendix because they're constantly changing.
They'll be reevaluated every 6 months. And
So-
it can fluctuate.
So they need to go up. I don't think.
Could go down.
But they,
It's tied to the reimbursement amount that the public defender gives to the county, so it's a budgetary rationale, but they will never go below what they were prior to July 1st.
now, the most important thing about local council board is 30 days. Get your fee bill in. If you don't get your fee bill in, you're not gonna get paid.
One other thing I would like to add, I'm sure you're all aware, but if you're not, the oral arguments that you're having are being recorded. We're obligated to do that by rule. We're doing audio recordings. It's the appellate rule 21J. Anybody can request those. We have a form for it under our forms, and you would just submit it to the email that's specified on the request.
Oh, and with regards to oral arguments, we have a process in place where a inmate may request oral argument if they file a pro se brief. And we will consider that. And then if the institution has a process where they have a camera, we will then allow oral argument by that pro se litigant.
Yes, we've been doing that all throughout the pandemic. I believe they joined by telephone at this point, but it's through Zoom.
All right, I'm gonna talk a little bit about motion practice in the Court of Appeals. Just some motion basics, in writing, filed with the clerk of the Court of Appeals, served on the parties. Be specific in your motion, especially in the relief that you request. If you include a memorandum in support, your conclusion paragraph could be exactly what you want the court to do. There's an option in the rules for a hearing on a motion in appellate rule 15. That is exceedingly rare. Most motions will be decided on the briefing that's filed. Your motion must also be signed, even though there's no appellate rule that sort of indicate that. We've interpreted it. Civil Rule 11's requirement for signature through Civil Rule 1 and Criminal Rule 1 to apply. So your motion needs to be signed with a signed certificate of service. The time you have to file a motion, then you have 10 days, the other party has 10 days to file a brief in opposition, and the rule does provide 7 days for a reply brief. However, the court may rule on procedural motions at any time, even before the time period has elapsed for a response. If you are affected by that, then you can file a motion for reconsideration within 10 days of that. So what is a substantive versus procedural motion? I'm not going to spend a whole lot of time on this, but substantive creates, defines, and regulates rights versus procedural is the manner in which rights are enforced. So what happens when you file a motion with the Court of Appeals? It's filed, they e-filed with the clerk's office for the court. It's processed by their staff. And this process isn't immediate. It can take time for them to process depending on the queue that they have at that time. And then it's transferred into our system, which is a separate system, and it also has to be processed by our court staff. So as a practice point, if you're filing an emergency motion in the Court of Appeals and you need to say yourself up for immediate or one immediate decision, you can't really control that. But what you could do is you would call the Court of Appeals, ask to speak to a staff attorney, tell them, hey, look, I'm filing this motion in this case. It's very important that I get a ruling as soon as possible. We can then alert our staff and the clerk's office staff to keep an eye out on this case to make sure we get that motion as soon as possible. And then we can get it to our administrative counsel as soon as possible. So that's what happens. The motion goes to the administrative counsel and then it go generally one of 3 places. If it's a first motion for extension of time, the court administrator, Aaron, will rule on those motions. If it's a procedural motion, if you go to the administrative judge most often, or if you go to a rotating panel, motion panel of judges, it rotates throughout the years.
I just want to, your emergency is not necessarily the court's emergency. So be aware that standing around in the hallway is not going to accelerate the process. Once it's filed, we know what we need to do.
These are some of the types of motions that each of the different options would handle. I just want to circle back to something Tony said about non-proton entries. If a non-proton entry is entered after the notice of appeal is filed, the Court of Appeals isn't necessarily aware of that, especially for a municipal court case where that may not be included in the record. So if you may want to file a motion to supplement the record with that attached journal entry of the non-proton entry. If you want that, you want to remove any sort of question of validity of that order because the non-proton was entered while an appeal was pending, then you may wish to file a motion for limited remand so that we could remand the case. Trial court could re-enter that order. No question of its validity then. Or if you want that to go away, you may argue in the brief, hey, look, Court of Appeals, this entry was entered without jurisdiction. So maybe even if you affirm, maybe you want to revert, you want to remand it back to vacate that order that was entered without jurisdiction.
That just makes me want to jump in right here on motions, just so everyone's aware in the criminal arena. The PSIs and the psych reports, we don't get those automatically, and you should be asking motions to supplement the record to include those. So that you have all the information that you need to advance your appeal on behalf of your clients.
I also want to highlight appellate rule 5 here. If you're in a criminal case, if you're filing a motion for delayed appeal, you need to serve the prosecutor's office. And similarly, if you're a prosecutor filing a motion for leave to appeal, you need to serve the public defender's office. And at the same time, you want to set your appeal up so that the court is in a position to do everything quickly right away if your motion is granted for a delayed appeal. So file a motion for transcript at state's expense or appointment of counsel so that we can handle all that at once and get the appeal moving forward. But did I say there are 3 options? There are actually a 4th option. It's our entire special effects budget right here. The motion can be referred to a merit panel. This can happen if the motion panel or the administrative judge feels that this should be a ruling that should be put in the hands of the panel hearing the case to decide. So if you get a journal entry that says the motion is referred to the merit panel, you won't get a ruling on it until a merit panel is assigned. And that doesn't stay your case. So your briefing schedule is still the same. Your brief is still due. If you need to file a motion or the court needs to enter an order staying anything, this doesn't automatically stay your schedule. So those are some examples of things that may be referred to the merit panel. And one of those may be a motion to dismiss. We see practitioners do this in a couple of different ways. A motion, they may file a specific motion to dismiss the appeal if they lack of a final appealable order, or they may argue that in the appellee brief sometimes. So how does the court handle those? Generally, if you file a motion to dismiss, there it is. Generally, if you file a motion to dismiss, it's going to be handled by a motion panel for the most part. And the motion panel may decide that it should be referred to a merit panel or not. So you may get a ruling soon, prior to your briefing schedule on that. But it may be referred to a merit panel and then it'll be decided after briefing. But if you argue it in your brief, most of the time that's going to go to a merit panel. So there's just 2 different options. But let's say you file a motion to dismiss and it's before the record has been filed with the Court of Appeals. How is the Court of Appeals going to handle that? There is an appellate rule that is exceedingly rarely used. Appellate Rule 10F allows for a party to designate portions of the record to be sent to the court by the clerk's office to decide the motion. If you decide to try to use this rule, be prepared for some blank looks from the clerk's office. They probably aren't familiar, they probably haven't had one in a long time, if ever. I talked to our administrative counsel, she's not seen this rule used, and she's been there for several years. So, you may need an order from us, you may file a motion with us directing the clerk to, and that's something you give the clerk, say, hey, look, here's an order from the court, please do that. But what we see more often is that parties will attach, as Appellate Rule 15A allows, parties can attach things to motions and affidavits. So we see certified copies of journal entries or, timestamped entries from the lower court record. And you may want to include an affidavit that saying these are part of the lower court record. Court of Appeals, you can consider this in deciding this motion.
You could just really run quickly through the Zoom protocols.
Okay. Oh, I did want to mention, just because Newton left it up to me,
Oh, yes.
for Appellate Rule 4A. Appellate Rule 4A is different, because it is not included in the Ohio Appellate Rules. We've developed a procedure for handling 60B motions that are pending below. So if there is a 60B motion pending, you can ask us for a limited remand. We'll send it back to trial court and rule on that motion. And then you need to file a separate notice of appeal from the 60B decision, and then move to consolidate that with the current appeal.
That was important, so thank you.
I'm going to skip the post-judgment motions. Jim talked about that a little bit. But I did survey the judges and asked them for anything they liked or didn't like about, basically 2 years of Zoom hearings. And so some of the things that I got are an appropriate place to argue your appeal. And to be well lit, minimize distractions. A car is not that place. At least 2 separate oral arguments occurred where attorneys argued from their car. I asked an AI to draw what it thought this would look like, and it was as deeply confused as the judges who witnessed this in person. And if your is not free of distraction, you may want to implement a virtual background to sort of free up if you have other coworkers or family members or pets in the background who may distract the judges or your audience from your argument. Virtual background, but make sure it's appropriate. Virtual background, palm trees swaying in the breeze, probably not appropriate from the solemnity of an oral argument.
And so just to be clear, this example is an inappropriate background.
Also judiciously use the mute and unmute buttons and familiarize yourself with that and practice with it. Some of the judges even called out their colleagues about not using it enough. So just make sure that you do use the mute and unmute buttons. And finally, video, some oral argument practitioners, some attorneys were just doing audio oral arguments without their video on. Some of the judges found this less than optimal. They liked it when they could interact with attorneys and see them. They also, one of the comments was that this is that the appearance wasn't what you would normally see if someone was coming into the courtroom to argue. So make sure that you dress appropriately and look presentable while in the argument.
Thank you. Yeah, just keep in mind, it is a courtroom, so whatever you're gonna wear in the courtroom, wear to the virtual courtroom.
I just want to add one thing. When we're screening these cases, sometimes we come up with a final appealable order issue that's not addressed by any parties. The court will issue an order to the parties to brief the issue. Please respond to that particular order. If we don't.
We're keeping them from lunch.
We'll make a decision without input from the party.
Thank you, thank you.
Also, we're available, like I said, if you have a question, give us a call, ask to speak to a staff attorney, the staff attorney on call, so.
So please feel free to grab a box lunch